The protection of intangible assets is a fundamental responsibility for any professional operating at the intersection of technology, law, and business strategy. This focused review consolidates the essential concepts of intellectual property law to ensure that the core pillars of creative and technical protection are firmly established in your mind. Typically, a clear understanding of these legal frameworks allows an organization to navigate the competitive landscape with a sense of security and professional poise. In practice, the strength of a company's portfolio depends on the consistent application of these rules to every new idea, brand, or invention. What this means is that we are locking in the foundational knowledge required to distinguish between different types of property and the specific ways they are defended in a global marketplace. Before we continue, a quick note. This audio course is a companion to our course companion books. The first book is about the exam and provides detailed information on how to pass it best. The second book is a Kindle-only ebook that contains 1,000 flashcards that can be used on your mobile device or Kindle. Check them both out at cyberauthor.me in the Bare Metal Study Guide series. A primary requirement for success in this domain is the ability to remember that patents, trademarks, and copyrights each serve a distinct and specialized purpose in the legal ecosystem. Patents are designed to protect functional inventions and new processes, providing a government-sanctioned monopoly in exchange for sharing technical knowledge with the world. Trademarks act as the guardians of brand identity, protecting the words, symbols, and designs that signify the source of a product or service to the public. Copyrights protect original works of authorship, ranging from the intricate lines of a software code base to the creative layout of marketing materials or manuals. Typically, identifying which protection applies to a specific asset is the first step in building a professional and legally sound governance strategy for the organization. It is highly beneficial to think back to the critical and absolute requirement of secrecy for any piece of business information to be protected under the legal category of a trade secret. Unlike other forms of property that rely on public registration, a trade secret only exists as long as the organization takes active and reasonable measures to keep the information strictly confidential. In practice, this means that the legal value of a secret is directly tied to the technical and administrative controls used to prevent its unauthorized disclosure. Typically, if a secret is revealed without the protection of a non-disclosure agreement, its legal life and its competitive advantage are permanently extinguished. What this means is that for this specific category of property, the primary defense is the height and the integrity of the walls you build around it. A significant point of professional clarity is found when one learns not to confuse the public disclosure required for a patent with the absolute and ongoing confidentiality required for trade secrets. To obtain a patent, an inventor must provide a detailed blueprint to the government that eventually becomes a public document for anyone to read and study. In contrast, the trade secret remains a private asset that is never registered with a government office and depends entirely on the owner's ability to maintain its hidden status. Typically, an organization must make a strategic choice between these two paths, weighing the benefits of a 20-year public monopoly against the potential of an infinite but fragile secret. In practice, this decision often depends on whether the technology can be easily reverse-engineered by a competitor who sees the finished product. You can effectively reinforce your learning by clearly defining the term prior art and understanding its massive impact on the success or failure of a new patent application. Prior art represents any existing evidence such as earlier patents, academic papers, or public products that demonstrates an invention was already known or used before the current filing. Typically, if a government examiner identifies prior art that covers the same technical ground, the new application will be rejected for a lack of novelty or non-obviousness. In practice, a thorough search for prior art is a mandatory step that ensures the organization does not waste its resources pursuing protection for an idea that the world already owns. What this means is that your technical research must be grounded in the historical reality of global innovation to be legally effective. It is helpful to picture yourself in a professional setting, confidently explaining the specific legal standard for trademark infringement, which is known as the likelihood of confusion. This standard does not require two brand names to be identical. It only requires them to be similar enough that an ordinary consumer might be tricked into believing the products come from the same source. Typically, a judge evaluates this by looking at the sound, appearance, and meaning of the marks, as well as the relatedness of the goods being sold in the marketplace. In practice, the goal of the law is to protect the goodwill of the original brand and to prevent the public from being misled by copycats. This visualization helps us see that the legal defense of a brand is focused on maintaining clarity and trust in the minds of the consumer. One can use the DMCA, Digital Millennium Copyright Act, as a powerful memory anchor for the formal process of removing infringing or pirated content from the internet in a legal and efficient manner. The DMCA provides the notice and takedown framework that allows copyright owners to protect their digital works without the immediate need for a costly and slow-moving lawsuit. Typically, by following the specific administrative requirements of the Act, a professional can ensure that unauthorized copies of software or media are taken down by service providers with significant speed. In practice, this statutory tool is the primary mechanism for maintaining the integrity of an organization's digital footprint across a vast and often chaotic online environment. What this means is that you are using a specific legal lever to enforce your creative rights globally. Reviewing the fundamental differences between the four types of intellectual property helps you remember which specific protection is best for complex software versus a simple company logo. While the logo is primarily a trademark used to identify the business, the software is primarily a copyrighted work protected by the specific expression of its source code. In practice, a single product often incorporates multiple layers of protection, such as a patented internal circuit, a copyrighted user interface, and a trademark product name. Typically, a seasoned professional knows how to stack these different legal tools to create a comprehensive and multidimensional defense for a single innovation. This level of organizational discipline ensures that every aspect of a new product is accounted for and shielded from every possible angle of competitive threat. It is worth taking a moment to imagine the direct and powerful link between rigorous intellectual property protection and the overall financial valuation of a modern, high-growth technology company. In the digital economy, the majority of a firm's value is often found in its intangible assets rather than in its physical buildings, machinery, or inventory. Typically, a robust portfolio of patents, trademarks, and trade secrets acts as a moat that protects the company's future revenue streams and its unique position in the market. In practice, during a merger, acquisition, or a round of venture funding, the quality of these legal protections is one of the most scrutinized aspects of the entire business. This realization highlights why your work as a protector of ideas is a direct contribution to the long-term wealth and strategic survival of the enterprise. Every professional strategy for intellectual property should be anchored in the recall of the specific symbols used to denote registered trademarks and copyrighted material in the world of business. The R in a circle symbol signifies a trademark that has been formally registered with a national office, while the C in a circle denotes a work protected by copyright law. In practice, using these symbols correctly provides a clear and professional notice to the world that the organization is aware of its rights and intends to defend them if necessary. Typically, while protection may exist without these symbols, their presence can impact the damages a company can recover in a successful infringement lawsuit. What this means is that you are using small but significant visual markers to establish the legal and professional boundaries of your organization's creative output. We have now summarized the primary protections, the significant risks, and the active enforcement strategies for all the major forms of intellectual property law that define the modern professional landscape. By understanding the life cycle of an idea from its initial conception to its final legal defense, you are building a more resilient and self-aware framework for organizational success. Typically, the most effective teams are those where the technical responders, the creative leads, and the legal counsel work in total harmony to identify and shield the crown jewels of the company. In practice, this ensures that the organization remains a trusted and unique leader in its field, protected by the full weight of the global legal system. This integrated perspective is what transforms a simple security program into a high-performing and business-aligned governance engine. A highly effective and quick win for your study progress is to take 2 minutes right now to list the primary, fundamental differences between a patent and a trade secret. You might note that a patent is public and expires after 20 years, while a trade secret is private and can theoretically last forever as long as it is never disclosed. In practice, this comparison helps to lock in the trade-offs that an organization must consider when deciding how to handle a new and valuable technical breakthrough. Typically, having these distinctions ready for instant recall allows you to provide better advice during project planning and to make faster decisions during a security incident. This small exercise helps to turn complex legal theory into a concrete and actionable set of professional standards for your daily work. Mastering these intellectual property essentials is a vital requirement for any professional who manages technical innovation, organizational branding, or digital compliance in today's competitive environment. When you can accurately classify an asset and understand its legal life cycle, you can apply the specific technical controls needed to satisfy the requirements of the law. Typically, the most successful practitioners are those who never take their organizational rights for granted and who treat every creative asset with the professional care it deserves. In practice, the energy you have spent on mastering these concepts is a direct investment in your own credibility and your ability to lead the organization through the complexities of the digital age. This focus on detail is what ensures that your governance program is a verified and trusted reality for everyone involved. This focused review of the essentials of intellectual property law is now complete, and you have successfully reinforced your understanding of the pillars of creative and technical protection. We have discussed the definitions of patents, trademarks, and copyrights, the role of prior art, the importance of the likelihood of confusion standard, and the value of the DMCA takedown process. A warm and very productive next step for your continued professional development is to take a quick, restorative break before we begin our journey into the next major domain of the curriculum, the world of privacy and data protection. Moving forward with this refreshed and consolidated mindset will help you master the intricate rules of personal information management with total professional confidence.
Thanks for listening. For more audio courses, daily newsletters, and more, please visit baremetalcyber.com.